What would happen in a case where a party trusted the other spouse or ex-spouse to pay the mortgage and then all of a sudden they didn't? Has that backfired?
Yes, absolutely. It's kind of hard to.
Hi, everyone. This is the Illinois Family Law Insider podcast. My name is Katie VanDeusen. I'm one of the managing partners at Sterling Lawyers. And with me today, I have attorney Reyna Herrera. Thanks for joining me today, Reyna.
Hi, excited to be here.
Awesome. So we are going to be talking today about who gets to stay in the house. When it comes to a divorce case, we have buyouts, refinancing, dividing equity. So we are going to be delving into this topic and talking about who gets to stay in the house and what happens with the house in terms of the divorce. So let's start with kind of temporary situations first, Reyna. So while a divorce is pending, who usually stays in the home during the actual divorce case?
I would say most often both parties do, just because, again, it's kind of hard to be able to afford the house expenses and then something else. And, sometimes, parties do move out if that's an agreement that they want to come up with. I feel like it's a common misconception that if you leave the house, you're like giving up the house, or you're giving up your rights to the house. And that's just not true. So as long as you both have a right to be there, you both can stay there. It's really up to, the parties how they want to handle that.
And so I heard you mention, Reyna, if someone wants to voluntarily leave, we always, I feel like, get this question, well, doesn't that mean I'm abandoning the property and it's going to negatively impact my ownership rights? And I heard you say, no, that's kind of a myth that's out there for whatever reason, and that you can, in fact, leave if you want to voluntarily move out and it doesn't negatively impact ownership rights. Is that right?
Yeah, definitely. But like I said, you have to make sure though that all the expenses, are being paid from the old house too, which is why most people just don't leave, because it's called like maintaining the status quo. So if you're always splitting the mortgage, you got to keep splitting the mortgage. You can't just decide like I'm not paying my half anymore.
Right. So that financial piece of things, if you do voluntarily decide to move out, while it may not negatively impact your ownership, you still have to financially maintain that asset. So that's something that we've got to talk to people about proactively and kind of figure out a strategic plan with regard to that. And then, can someone force someone out of the house? When does that kind of play a factor in cases?
I would say those are very rare and extreme cases. So, if there's domestic violence involved, orders of protection, which again, those are a high burden to meet. They just require a lot of proof to show that, your safety is so impacted that the other person, needs to leave the residence. And the judge also has to approve that. So absent a court order, unfortunately, I feel like that's another hard conversation and we always have to have with clients. Like, I get it's an uncomfortable situation. You're still living with someone who you no longer want to be married to. But absent that like very real safety concern, you can't really do anything.
And then have you ever had a case where both parties maybe like refused to move out? They really, one person didn't want to leave. How do courts handle those types of situations?
I would say kind of the same analysis, absent like a very real safety concern. If both parties have a right to stay in the house, they both can stay there until, a divorce is finalized. And if they can't agree on what to do with the house, then the judge is going to be like, okay, again, you're both just staying there until it's sold. That's really the analysis that I feel like most courts do, or at least in my experience.
Yeah. And you referenced, safety concerns. So we have either a request for exclusive possession, which I think is always so difficult to, meet the required legal burden to show that one party should have exclusive possession of the home over the other. And then we also have orders of protection. So those two things kind of come into play whenever there's safety concerns, like you mentioned, Reyna. And I think it's kind of difficult to bring those to light. I think those definitely, you have to have the facts that warrant support of a request like that. And those types of discussions with clients are hard. They really are difficult, especially like you said, when it's an uncomfortable situation. So kind of shifting gears and going towards equity and understanding, how do judges handle homes and home equity? So how is a home's value determined? Can you kind of walk us through that?
Yes. So it's going to be the fair market value. So what the house would sell for today, not, what you bought it for. And anything minus or subtracting anything still owed on the mortgage, that's going to be your equity. So that's what, that's like the interest for both parties.
And then in terms of like deciding or determining value, we've got appraisals, we have comparative market analyses, we also have maybe a stipulation or agreement as to fair market value. So we always have to kind of keep in mind as attorneys which route is best for our client while also still weighing like the cost benefit analysis. So I always feel like that's an additional layer of how do we come up with the fair market value of a house. And then what does a buyout really look like? Like if a buyout is going to occur, how is that structured?
Yeah, I feel like this is also a hard conversation with clients because they're like, I want to buy out the house, not really understanding again that you're buying it for what it's worth today. So you have to, again, like that 50% equity, like the 50-50 split is of the equity. So if the equity in the house is like 200,000, you have to buy out the other side for $100,000. And that's really, I feel like the most common way to do it.
Yeah. And how does someone, how do we go about deciding how that's split? I know you referenced 50-50, or is there a possibility that it could be some other type of percentage allocation? How does that work?
That depends honestly on a lot of different factors and also, the approval of the judge. So the judges are there to decide, if this marital settlement agreement, this division of property is equitable. And as long as they feel it is, they're willing to enter that agreement. But that can look like 50-50, or, if one party just put in more money, or, they spent more time making improvements, things like that. Or if they put in like more non-marital property, that could be a different division versus just 50-50.
And I also feel like the kids are definitely a factor in that and like maintaining stability and whether someone buys out someone else and, keeping the kids within a certain school district. So all of these things kind of go into what do we do with the house? How do we, best approach that particular topic and what's best in that given situation? And then have you ever worked on a case where someone decided that they wanted to keep the house or be awarded all of that equity as an offset against something else, like let's say, for example, retirement.
Yes, I feel like that does happen very often. Again, just because it's really expensive to buy someone out. So they'll forego maintenance or they'll forego, their retirement interest. I think an important thing to keep in mind, though, is the tax implications because that's very different with retirement accounts versus just buying out someone for the equity in a home. You can't really get a dollar for dollar match in that scenario.
Definitely. And when it comes to, I heard you say someone wanting to keep the house and kind of having that be the route that they want to take in terms of either foregoing maintenance, offsetting retirement or other assets. What happens to the mortgage if one person keeps the home?
So I feel like there's two options. The first one is you have to refinance in your name, which again, I feel like most clients are like, well, I don't want to refinance. The interest rates are so high. But the
Right.
judge can't really force someone to stay on the mortgage if they don't want to. So again, you kind of have to get that approval for yourself from the bank to refinance. Or, you can agree to just assume the loan. But either way, unless the other party agrees to remain on the loan, you have to kind of figure out a way for yourself to be able to afford it.
And then have you ever had a case where someone really either didn't have the income or the support payments to qualify to refinance and remove the other person or, apply for a loan assumption or maybe have a cosigner, they just couldn't do that financially?
Yeah, and again, that's a very hard conversation, especially if there are kids involved or, like they've been in this home for 20 years. But again, unfortunately, you kind of just have to either be able to afford it or the judge is probably going to order a sale because, again, it has to be equitable. The judges are not going to put someone in a financially unstable situation, especially if there's kids involved.
Right. And so, in a situation where maybe someone is just asking for time, right? Like, let me get time with either additional support payments or income to qualify to refinance. What is like a realistic timeline that you've seen based on your experience? Or what options do people even have with regard to that?
Yeah, I feel like the most I've seen is 2 years. The parties will agree to both stay on the mortgage or, both maintain this house for the kids' stability. Or, some people agree even, up until the kids go to high school so they can finish out in that district. But that is also very dependent on, the facts of the case. Can both parties afford to maintain that asset? And ultimately what the judge says. If the judge finds it equitable, if he thinks it's fair, or she, sorry,
Yeah.
I think it really just depends on all of those things.
I agree. And it's really hard too because I think that is dependent on the parties and how open or flexible they may be with those types of ideas. If it's a more litigious circumstance where the parties are maybe fighting about those types of things, I think that that timeline shrinks, right? We're getting to a point where maybe it's 6 months or 1 year at most because judges really want to see that severing the parties financially. So I think you're exactly right when you reference there's so many different factors that could impact that or affect that one way or the other in any given case. Do you feel like it's risky to keep, maybe let's say like your client is the one who's agreeing to have the other party maintain that asset or keep that asset or be awarded that asset? Is it risky to have your client keep their name on the loan for an extended period of time in a house where they're no longer living in it?
Definitely. I feel like it could possibly impact their credit, if the other party's missing mortgage payments or, they're not caught up on whatever bills, that's going to negatively impact the other person's credit score, even though they don't live there anymore. If the city again requires, certain things be done to the house or like the furnace breaks down, things like that, you might still be on the hook for those financial responsibilities, even though you don't technically live there anymore.
Yeah, you really have to be very careful and cautious when entering into an agreement like that to really protect your client in those circumstances and kind of be thinking of like, what's the worst thing that could happen over the course of the next 6 months to 2 years, or, just to try to protect them. But what would happen in a case, Rena, where let's say a party trusted the other spouse or ex spouse to pay the mortgage and then all of a sudden they didn't? Has that backfired? Or could that backfire?
Yes, absolutely. And again, it's kind of hard to argue that you should be off the hook for, those financial obligations because your name unfortunately is still on it. And like legal ownership does not necessarily always translate into a loan obligation.
Right.
So, and like third parties are not really bound by divorce decrees. So, when collections agencies are calling to get something paid, they're just looking at who's on that loan and they're going to, require that both parties contribute.
Totally agree. It's really tough. And in those circumstances, you have to just mitigate risk as much as you possibly can. And you can never, guarantee that that's going to fully absolve someone in that instance. And how do you advise clients when there's maybe like an emotional attachment to the house? Because I feel like that happens a lot where maybe financially speaking, it's not the best choice in terms of like the budget, but people are really emotionally connected and tied to their houses or their homes.
Definitely. Like I said, divorce is not easy. These are definitely hard conversations to have, but you kind of have to level with your client to get them to see that while this is, a house that they've always known, the financial reality of it is just they cannot afford it. And, absent an agreement of the parties where they do agree to both maintain this asset, the judge is, probably just going to order that it be sold. And, again, like you sympathize, you kind of just have to weigh the pros and cons and get them to see that in the end, you receiving like the money from the buyout will allow you kind of a fresh start and to move forward.
And so in your experience, Rena, have you ever had a case where, selling the house actually ended up maybe bringing unexpected financial relief or allowing the parties to have a fresh start financially?
Absolutely. I feel like people see selling the house kind of mostly as like a negative thing, but if the parties have accumulated a lot of marital debt or, like for those situations where the party just really does want to move out but can't afford it, having those proceeds just really allows them to get a place of their own, move forward, or, contribute to like college contributions and things like that, even for the kids. It really is a fresh start for a lot of clients just to sell the house and kind of close that chapter.
And so, in terms of closing today, Raina, after what we've discussed, what's the first thing someone should do if they want to keep the house as part of a divorce case?
I would definitely advise, going to the bank or talking to your loan processor or whoever services your mortgage and seeing if you, one, qualify to refinance, kind of just taking stock of all your savings, if you can afford to maintain the house, things like that. I would say like that would be the number one step is to see if you can qualify to keep the house and afford it by yourself.
And then, what do you feel people misunderstand about legal rights when it comes to the home, especially if they're not on the title or mortgage?
I feel like the timeline gets a lot of people. So again, if you bought a house and you've been dating for 15 years and then, all of a sudden you're married for 2, but you've never been on the title or mortgage, if the house was bought prior to the marriage, it's just going to be whoever, was on the first title and mortgage. If you never refinanced, if you were never added, unfortunately, even though you've lived in this house for like almost 20 years, it's just going to be that individual's property, which I feel like is where a lot of people, it's a tough conversation to have, that they kind of have no rights in this home.
Right. And then we've got to come up with creative ways to salvage that in some way, shape, or form when it comes to legal argument and just minimizing that exposure and helping them in any way we can. So
Absolutely.
yeah. Well, thank you so much, Reyna, for joining me today to kind of talk through who gets to stay in the house, how do courts deal with buyouts, refinancing, and allocating equity. And I really appreciate everything that you shared today. I thought it was really insightful, and hopefully the listeners gained a little bit of knowledge with regard to those topics. So thanks for joining me.
Thanks for having me.
Keeping the home may feel like a win, but do you even know what counts as yours in the eyes of the law? Most people don't. Up next, we will walk you through what's considered marital property in the state of Illinois and what's not.